October 18, 2024.
Right.
Come up, Mr. Robinson.
It looks like it was just a late filing, so they filed with the sheriff.
Who's the complaining witness in the assault case?
It is it says acquaintance, 19-year-old, just going through now.
So it looks like this case was in October of last year before this terroristic threat. So we're not going to do anything to the bond. Okay, just be careful. Don't have contact with the person in the assault case.
May I ask one question, Sharon?
Sure.
I just moved off of my netta and wondering when I get back to the new outreach community church program and get the address, I'll make sure I give it to my lawyer because nobody's given it to me since I moved there yesterday.
Okay, just all we ask is don't have contact with these people. Don't go
Yes.
over there. Just don't talk to them, and all will be well if you just.
Yes, sir.
That's it. And no weapons too.
Oh, my gosh.
So we're gonna create bond conditions for you. We'll have you sign it, and then you're free to go.
Okay.
I just bought what they gave me when I got out. It was a G.
But they
Oh,
put
So
your
you already
GPS.
posted bond on that. That's good.
Sorry, y'all. I'm
Okay.
sorry.
Did they give you a GPS?
He has the bond already,
Oh,
Joe. He
okay.
just posted bond. He has a bond on the case.
You got a free bond, right?
Yes, sir.
Yeah, okay.
Yeah.
Got it.
Sorry.
All right, take care.
Did you find PC on the new one? Or?
Oh,
It was,
Have we not done PC on it?
Tomorrow.
Oh, yeah, he said tomorrow.
I guess let's do it, please.
Officer was assigned to a case follow-up investigation for assault bodily injury that occurred on 10/18/2024. Officers made contact with the complainant. Complainant stated the incident occurred on the corner street bakery near Main Street Square. Complainant stated that he was talking to a friend. Complainant stated that he was sitting down. He saw the defendant grabbing metal water bottles and threw it against the head of the complainant. Complainant stated this caused him to lose consciousness and a laceration on his head. Complainant stated he felt pain. Complainant stated he ID'd the defendant. Complainant texted the officer an image of the injuries. Officers stated that the image showed a laceration of the complainant's head. Officers created a photo spread using the defendant's most recent mugshot. There was a photo, a six-pack lineup spread.
So both just complete unknowns. So it
It
doesn't.
appears that way, Your Honor. It does show in the office report that they were acquaintances. But I don't, sometimes they say that, and it's not the case. But a mugshot was done and or a mugshot lineup was done. The defendant the complainant ID'd the defendants. They met with the complainant on 3/19/2025, when they administered the double blind photo spread, and he positively ID'd the defendant.
Understand, all we want, Mr. Robinson, we want our street safe. We
Yes,
don't
sir.
want people that are walking down the street and they're scared to walk down the street because they're gonna get assaulted,
Yes,
you
sir.
know? You now have 2 open cases. Don't pick up a third.
Yes, sir.
It's just not gonna go well. So don't have any contact with this person, no weapons and all is good. All right?
Yes, sir. Yeah, my word.
They're gonna create the condition, we'll have you sign it, and after that, you're free to go.
Yes, sir.
Thank you.
sir.
And Your Honor,
Yes.
no contact, no comments.
which one you want to go?
He'll go with the clerk so he can sign with the.
Today's
court.
episode takes us to Harris County Criminal Court in Houston, Texas, where Judge David Fleischer has built a reputation for scrutinizing the state's evidence and ensuring the government meets its constitutional obligations. Across a series of recent hearings, Judge Fleischer presided over probable cause determinations for 3 different defendants, and then returned to one of those defendants for a separate proceeding, raising its own distinct legal questions. So let's dive right into our first case. Michael Jones, who was charged with interference with public duties on January 10th, 2025. Mr. Jones failed to appear at his first setting on January 17th, 2025, resulting in his bond being revoked and a warrant being issued for his arrest. He was taken into custody on February 17th, and on February 19th, attorney Lisa Tichy appeared in front of Judge Fleischer to argue probable cause on Mr. Jones's behalf.
Hi, good morning, Judge. My client is Michael Jones, and he's in custody, and he's asked me to argue probable cause for him, and so I
Sure,
shall.
of course. You ready?
Yes, Judge. Does he need to be brought out, or do you, I don't know your process.
Mr. Jones, please.
He asked me to do this, and so I told him I would.
Yeah, this is Michael Jones.
Yes, Michael Jones.
He must be unhappy, huh?
Asked him to breathe.
Or hungry.
Asked him to breathe.
Good morning. How are you?
Hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No.
Just losing?
Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away. And it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and
Didn't say that.
That was in the complete dims, Your Honor. And then it
Did you know
says
about that?
and
Yes,
aggressive
Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. "I smell marijuana. You look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, "We identified ourselves as police," so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, "I'm the police, stop." We don't live in that kind of society. "I'm the police, I need to investigate you, so therefore stop," all day long. "I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter," all day long. But hey,
So-
I'm the popo.
The reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called as a disturbance, and they saw him yelling, being aggressive. And then as he walked away, that's when they saw
So
signs.
yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Yes.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred to determine,
He's leaving.
He's walking
He's
away.
leaving, right? It's like, here, let me come and mess with you more.
That would only,
right? So it's like adding fuel to a fire.
but they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to miss one.
Well, they're going up to investigate what they saw, him refusing to leave, and he
leaves.
only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm gonna find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we?
Yeah.
You don't like to wear orange, do you? Be careful where you go. Be careful what you do.
Yes, sir.
Everyone's always out to get you, man. Don't let them.
Yeah.
All right, man. Good luck.
Thank you.
Unless you.
I
Thank you,
didn't hear what happened.
Yes. But I will go over it.
Great state of Texas.
Yeah, it was one big off the mail.
You are Tavion Williams.
Sir.
Mr. Williams, you now stand charged with yet another case. Terroristic threat of a family or a household member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On March 30th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a disturbance and made contact with the defendant and the complaining witness. The defendant were in a previous dating relationship for 3 to 4 years. The complaining witness stated that the defendant was upset because the complaining witness broke up with him. But it was stated that the defendant had called and texted her multiple times. On one such call, the defendant stated that he would go to her location, punch her in the face, and break her phone. The complaining witness stated that she then stopped answering the defendant's calls. The defendant then showed up at her location and attempted to make contact with her multiple times and grabbed her arm from across the counter. The complaining witness stated she
And did what?
grabbed her arm from across the counter. The complainant witness said she was in fear for her life. Witness, the complainant was probably in front of the events and also described another incident. The event showed up to complaining witness's job and threatened her life.
Since December of last year, Mr. Williams, unlawful carrying of a weapon, felony UUMV, evading arrest, gun case, felony gun case, and now a terroristic threat. Within a matter of 2.5 months, you have picked up 6 cases. What on earth is going on with you? We will now find out. I'm ordering you now to go take a drug test, and you will return tomorrow so we can fulfill the bond conditions. If you so far as have any contact with this person, I'm going to make your bond so high you'll have teeth falling out. Do you understand? You are not to be in possession of any weapons, and I'm going to put a monitor on your ankle so I know where you are at all times. The next case you pick up, I'm going to freaking lose it. Do you understand?
Yes, Your Honor.
So I'd like to send him for a test now. And then right afterwards, he gets a GPS monitor, not to go within 500 feet of where the complaining witness lives, works, no weapons, no drugs, no alcohol, and then we will return tomorrow to discuss the results. We will also, in the interim, give you an application to fill out, and you can bring that back tomorrow to see whether you qualify for an appointed lawyer, sir. that way.
Hey, Judge.
What starts as a routine bond discussion quickly becomes a serious warning about staying away from an alleged assault victim. The court is dealing with a defendant who already has an open case, and now another assault allegation is being examined. The judge makes one thing clear. There will be strict conditions, including no contact with the people involved and no weapons. Then the court hears the allegation behind the new assault case, including a claim that a metal water bottle was thrown at the complainant's head, causing a loss of consciousness and a head laceration. The defendant is also identified through a photo spread, with multiple cases already hanging over him. The judge warns that picking up another case could make things much worse. But this courtroom session is about to become even more intense when another defendant appears with an alarming string of new charges.
Hey, Judge, good morning.
Thanks, man. You never been this busy before, huh?
Hey, love hanging out with us is what it is.
Okay.
Gentlemen, morning.
Hi. Who you here on?
Judge, actually, I'm here acquiescing to Mr. Day. He asked me to come in. I came in today for his benefit.
This one's
You're
awesome.
so nice.
It's case number 2558011.
You have a pre-signed waiver or something on Sweat?
Yes, for Sweat, aka Jeffrey, we have a pre-signed waiver for Michigan. They are requesting an extension.
Michigander?
Yes, Judge.
Do you want me to explain this to him?
This is off docket, Judge. He's not here today. Would you like to put him on docket?
It's if you guys want. I see that, what's he wanted for? A parole warrant? Okay. No, there's no need. I mean, I'll just sign the, have you talked to him at all or no?
I have not, and that's kind of an issue, Judge.
Why don't we put him on for tomorrow? So you
Okay.
can explain to him the pre-sign waiver process so that he knows, hey, not everybody looks at what they're signing, so I have no idea what it's pre-signed waiver.
Do you want to hold off the order until tomorrow, Your Honor? Okay,
Judge, the only thing is tomorrow's kind of tough for me. Can we do Wednesday? Let's do Wednesday.
Sounds
But I
good.
mean, if he's picked up between now and Wednesday, then it is what it is.
So that's why they kept oscillating, but just to be safe, they wanted the order put in the event that they need to fluctuate their travel dates.
I doubt Michigan's gonna be here within the next 2 days, but
Okay, so we'll put him on Wednesday.
Sounds good.
here, do you want to make a copy of this so you have it too?
They will provide.
Yeah, I'll scan, and send it to you. Thank you. All right.
December 17th, 2024, just 3 days after Judge Fleischer's no probable cause finding on the terroristic threat charge against Mr. McCollum, Harris County Pretrial Services filed a bond condition violation report in his failure to identify case. Pretrial Services reported that Mr. McCollum's GPS monitoring device had been offline since December 14th, 2024, rendering them unable to track his location. The court ordered Mr. McCollum to appear in front of Judge Fleischer on December 18th, 2024 to address the violation.
I'm not happy with you. You have a monitor on your ankle. It's been dead. Is it still dead now?
I keep my charger with me. I keep it with me wherever I go. But my ankle monitor is messed up. They said it's malfunctioning, so sometimes.
Felicia, tell me what's going on with Mr. McCollum now.
I believe on the 2nd, we lost service until the 5th. And then it came back on, and then on the 8th, his last court date, it went off again for about 6 hours. I reached out to get the specific times, but I haven't heard back yet on that. But it was off for a confirmed 6 hours, and we have received signals since then back.
Yeah.
And we send messages out to tell them to report 49 to have the device inspected as well. And if they have any issues with that, they're instructed very thoroughly to let us know.
Yeah, I keep my charger with me, though, but I think it's something wrong with my thing, because the thing got off and it gets wet when I get in the shower.
You keep your charger on you, but you don't use the charger because it has gone dead over and over. And I don't care if you come here with a baby to try to save your ass from going into custody.
I'm not trying to save him. I'm the only one that could have watched him right now.
What's going to happen if you go to jail? These are things that you think about when you're in the free world and when you have bond conditions. Because when you break the bond conditions, what happens to you?
So I did call them and tell them that I think it's a malfunction with my team. They said they could see my signals, and they give me.
You repeatedly have the device that goes out. I'm going to do this. I'm going to do that. I'm going to call this people. But you are, though. The device has gone dead. 3 days over there, now 6 hours over here. What am I supposed to do?
I was unaware of it being dead. I put it on the
She's
charger.
telling me they reached out to you.
No, they do. Every time they call me, I put it on the charger. They call me. They do call me and I put it on the charger.
Why do they have to call you to even tell you to put it on the charger, Mr. McCollum?
Sometimes I'm at school. A lot of times a day I can't charge it at school. My charger is not close to my barber station.
So why can't you charge it at night when you're at home with the baby?
I do. Sometimes it acts as if it's charging, but it's not charging. So it's not that I'm not trying not to charge. I do try to charge it every day.
Judge, I would ask if the court would instruct him to go by 49 Sanderson today, just for them to check the device, and if there is something wrong, for them to put it.
I'm putting him in jail. I don't know what you're going to do with this kid, man.
I haven't done anything wrong, sir. I promise.
But you have done something wrong. You've repeatedly done something wrong.
But my ankle monitor, like, I didn't know it was dead. I promise you, I go to school every day. This is what I do. Like, I go to school.
How does the monitor let him know that it's dead?
So, we send messages, and then I also see, a few times we send siren alerts to the device as well.
Yeah,
And then I have
charge it.
multiple dates of text messages informing the client to charge the battery as
And they
well.
call me and I answer the phone and I charge it. I charge it every time they call me. I'm not making no excuse. This is what I do. I go to school every day.
The reality is you tell me something, but the machine tells me something different, Mr. McCollum. That's the reality.
Ask if we could get, like, can we get it inspected or get it checked out, please? Because I know it's not.
That is what you're supposed to do at the first instance that there is a problem.
I did call them and it's on record.
You
call them.
calling has nothing. It doesn't do anything. You have to actually go down to the place and have it serviced if it's malfunctioning. But you don't.
No malfunctions with it, sir. I promise. I called them. They told me it was no malfunctions because it was going off at first when I was at school one time. I said, "What's wrong with it?" I've never been on ankle monitor before, so I said, "What's wrong?" When I called them, they said, "Do you have service to outlet?" I said, "No, but I can get." I went to a place next door to my school and I tried to charge, and they said they still not getting signal from. They still weren't getting signal. So if we can get it changed or get it looked at least,
Judge, I would ask if he could get a new device, if we could reset this a week, and if
Here's what we're going to do. I'm now sending you for a drug and alcohol test. I want to know what, if anything, is in your system.
Sir.
Do you understand?
Sir.
You were to come back tomorrow. Don't come with a baby. Do you understand me?
Sir.
Don't come back here with the baby.
Sir.
Because if you're here and I put you in custody for one reason or the other, I will call CPS. Do you understand?
Sir.
But here, whoever you are, I don't care who you are, we will hold you accountable. And if you continue, piss on my leg and tell me it's raining, do you understand? I will not entertain you telling me I got to do this, I got to do that, and I've malfunctioned this. They reach out to you ad nauseum to tell you that there are issues, and you coming here and telling me, well, I don't know about this, I don't know, it's disingenuous.
Nice. We get it. Ankle monitor looked
just go to 49 Sanderson.
Where is that?
49 Sanderson.
First thing is first, I'm sending you for a drug and alcohol test. And then I will give you the benefit of the doubt right after. Have you go to this place to see if there actually is something wrong. You will be back here tomorrow. Understand? Okay, Hunter.
Judge, they will, do you have someone else to watch the baby because they won't allow the child?
Do you have someone here with you today?
No, sir. But I'll just wait outside the address until I can get somebody to come.
Do that.
Yes, Judge.
All right. All right, Judge. See you, Mr. McCollum. We'll see you tomorrow. Okay, you want to bring him up and we can just get it done? Are we doing time serve?
Yes, Your Honor.
Yeah.
You know, Mr. Herrera. So you talked about a PTI and he doesn't want it?
They denied it, Your Honor.
Oh, it's denied.
Yeah.
Okay.
Yes.
So, Mr. Herrera, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand that this charge will now go on your record. It's going to be there for the rest of your life. I would never, even if you have a sip of alcohol, I wouldn't get into a car. When they look your record up, if you get pulled over and an officer smells it, it's probably not going to go well for you. And what we're doing today, from now on, it's a minimum of 30 days in jail for any new cases that you pick up. No more proverbial slaps on the wrist. Do you understand?
Sir.
Judge, I don't know what the credit or the time was, but he has 1 day credit. I'm not sure.
So whatever it is,
Okay.
you're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never change this. Are you sure you want to do this?
Yes.
How do you plead to the officer, guilty or not guilty?
Yes.
Are you sure? If you're not guilty, then don't plead to it, man.
Oh, no, yeah.
Because once you plead, you can never change this. This isn't Target where you can return it because you don't like it. Are you sure?
Sir.
Okay. I'm going to find you guilty, Mr. Herrera. Let me make something else abundantly clear to you. Your lawyer is asking for me to waive what would otherwise be a $3,000 surcharge that would normally apply to you. We all make mistakes. But if you continue to make mistakes where you endanger other people's lives, that's when the sentences get a lot more serious. A second DWI, like I said, it's a minimum of 30 days in jail and a $6,000 surcharge. So if you come back with another DWI, do you understand?
Sir.
If you want to get lit, take an Uber. $40, anywhere you want to go in this city. How much money have you spent? You know what I mean? Good luck. All right, thanks. And that's a wrap, so you can fill it out and bring it back tomorrow. Mr. D.
Yes, sir, Your Honor. The chief and I need to talk to you about something, Your Honor. It's my understanding that the chief is not amenable to 12-month deferred on the one of the thefts. It's my understanding that he's willing to accept 18 months. However, he said he would.
I'm okay with whatever.
And Your Honor, I said I didn't come to you too. The only reason, Your Honor, there was a PTI for 2023 on this year. It was the case was the PTI, then we had the theft, a new theft.
What was the original PTI on? Not on a theft though. Interference?
Your Honor, I'll come to you. Obviously, I'll always give that option. I just think given.
You want to do an 18-month deferred?
I would offer it.
What do you think? Because we can always early
He
terminate.
just told me he wouldn't be willing to do an 18-month.
Well, but what I'm telling you is if he does well, I'll terminate him early.
I told him that he would terminate it in 9 months.
Come on up. Your alternative is a conviction. And I'm telling you now, the conviction will hose you for the rest of your life. We're trying to save you from yourself because sometimes people are their own worst enemy. And that's you now. You're continually shooting yourself in the foot. Life is hard as it is. And when you start racking up convictions, especially theft convictions, it just gets so much worse. I promise you, it's not fun. This life is about one thing. It's about having fun, making a lot of money, getting to buy nice things, going on nice vacations. And when you get that theft conviction, no one gives you a job. No one's going to give you, because they know that you're going to steal from them, given the opportunity. That's why we have convictions, to put the entire world on notice of what type of person you are. That's why you want to avoid as many convictions as you can, because once you get that notice and once the entire world knows you're that type of person, they don't give second chances. Very few times. I'll do whatever you want to do. If you want to take a conviction, you can do it. If you want to do the deferred, what we do is we reward you. If you do well, we take you off early. It could be 6 months. It depends on you. If you get it done really quick, I can take you off in 4 months. I can take you off in 6 months. It depends on how well you do it. You're the master of your own domain.
I'll
I'm
take.
just trying to save you from yourself.
Is this the final
Yes, sir.
decision?
Yes, sir.
It's up to you. They can write it up for 3 years, 4 years, 5 years. I'm the one that can early terminate you, right? And that depends on you. If you do well, you don't test positive, get your stuff done quick, we'll take you off quick. The idea is that you learn from this, so you don't pick up another case. At some point, you're going to get the itch to take something. Don't. It's just not worth it. You know, whatever the stupid ass thing in the store that you want, it's just don't. Work and you get it on your own. You know what I mean?
So,
Okay.
Thank you.
Whatever you want.
Thank you, Your Honor. Okay, all right. You the right thing.
This courtroom session ends with a very different kind of warning. Mr. Herrera accepts a guilty plea to driving while intoxicated, and the judge makes sure he understands that the conviction will remain on his record. The court also warns him that future cases could bring significantly harsher consequences, including a minimum of 30 days in jail for a new case under the judge's stated policy. The judge repeatedly emphasizes that pleading guilty is a serious decision and confirms that Herrera understands he is giving up important trial and appeal rights. After finding him guilty, the judge also explains that a fee was being waived and gives a